be individual or collective. The court is also of the view that in its classical conception, the right to property usually refer to three elements, namely the right to use a thing that is the subject of the right, usus, the right to enjoy the fruit thereof, fructus, and the right to dispose of the thing that is the right to transfer it, abusus. However, to determine the extent of rights recognized for the indigenous communities in their ancestral lands, as in the instant case, the court holds that Article 14 of the Charter must be interpreted in light of the applicable principles, especially by the United Nations. In this regard, Article 26 of the United Nations General Assembly Declaration 26/295 on the rights of indigenous people, adopted by the General Assembly on 13 September 2007, provides as follows. We quote, "Indigenous people have the right to the lands, territories, and resources which have traditionally owned, occupied, or otherwise used or acquired." 2. Indigenous people have the right to own, use, develop, and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those which have otherwise acquired. 3. States shall give legal recognition and protection to these lands, territories, and resources. Such recognition shall be conducted with a due respect of the custom, tradition, and land tenure system of the indigenous peoples concerned. End of quotation. It follows in particular from sub-article 2 of Article 26 of the Declaration that the rights that can be recognized for indigenous people / communities on their ancestral lands are variable and do not necessarily entail the right of ownership in its classical meaning, including the right to dispose thereof, that is, abusus, without excluding the right to property in the traditional sense. This provision places greater emphasis on the rights of possession, occupation, use / utilization of lands. In the instant case, the respondent does not dispute that the Ogiek community has occupied land in the Mao Forest since time immemorial. In the circumstances, since the court has already held that the Ogieks constitute an indigenous community, supra paragraph 112, it holds on the basis of Article 14 of the Charter, read in light of the above-mentioned United Nations Declaration, that they have the right to occupy their ancestral lands as well as use and enjoy the said lands. However, Article 14 envisages the possibility where a right to property, including land, may be restricted, provided that such restriction is in the public interest and is also necessary and proportional. In the instant case, the respondent's public interest justification for evicting the Ogieks from the Mao Forest has been the preservation of the natural ecosystem. Nevertheless, it has not provided any evidence to the effect that the Ogieks' continued presence in the area is the main cause for the depletion of natural environment in the area. Different reports prepared or in collaboration with the respondent on the situation of the Mao Forest also reveal that The main causes of environmental degradation are encroachments upon the land by other groups and government accession for settlement, and ill-advised logging concessions. In his pleading, the respondent also concedes that, quote, the Mau forest degradation cannot entirely be associated or is not associable to the Ogiek people, end of quotation. In this circumstance, the court is of the view that the continued denial of access to and eviction from the Mau forest of the Ogiek population cannot be necessary or proportionate to achieve the purported justification of preserving the natural ecosystem of the Mau forest. It follows, in views of the foregoing consideration, the court holds that by expelling the Ogieks from their ancestral lands against their will, without prior consultation and without respecting the conditions of expulsion in the interest of public need, the respondent violated the rights to land as defined above and as guaranteed by Article 14 of the Charter, read in the light of the United Nations Declaration of the Rights of Indigenous Peoples of 2007. Alleged violations of Article 2 of the Charter. Article 2 of the Charter provides that, we quote, every individual shall be entitled to the enjoyment of the rights of freedoms recognized and guaranteed in the present Charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political or any other opinion, birth, or any status, end of quotation. Article 2 of the Charter is imperative for the respect and enjoyment of all other rights and freedoms protected in the Charter. The provisions strictly prescribe any distinction, exclusion, or preference made on the basis of race, color, sex, religion, political opinion, national extraction, or social origin, which has the effect of nullifying or impairing equality or opportunity or treatment. The right not to be discriminated against is related to the right to equality before the law and equal protection of the law as guaranteed by Article 3 of the Charter. The scope of the right to non-discrimination extends beyond the right to equal treatment by the law and also has practical dimension in that individuals should in fact be able to enjoy the rights enshrined in the Charter without distinction of any kind relating to their race, color, sex, religion, political opinion, national extraction, or social origin, or any other status. The expression any other status under Article 2 encompasses those cases of discrimination which could not have been foreseen during the adoption of the Charter. In determining whether a group falls under this category, the court shall take into account the general spirit of the Charter. In terms of Article 2 of the Charter, while distinctions are differential treatment on grounds specified therein are generally prescribed, it should be pointed out that not all forms of distinction can be considered as discrimination. A distinct or differential treatment becomes discrimination and hence contrary to Article 2 when it does not have objective and reasonable justification and in the circumstances where it is not necessary and proportional. In the instant case, the court notes that the respondents' national laws as they were before 2010, including the Constitution of Kenya 1969 as amended in 1997, the Government Lands Act Chapter 280, Registered Land Act Chapter 300, Trusts Land Act Chapter 285, and the Forest Act Chapter 385 recognized only the concept of ethnic group or tribe. While some of these laws were enacted during the colonial era, the respondent maintained them with few amendments on their effect persistent to date, even after independence in 1963. It is for all the Ogieks, insofar as the Ogieks are concerned, the court notes from the record available before it that their request for recognition as a tribe goes back to the colonial period, where their request was rejected by the then Kenya Land Commission in 1933, asserting that, quote, they, that is the Ogieks, were a savage and barbaric people who deserved no tribal status, end of quote. And consequently, the commission proposed that, quote, they should become members of and be absorbed into the tribe in which they have the most affinity, end of quotation. The denial of the request for recognition as a tribe also denied them access to their own land. At the time, only those who had tribal status were given land as special reserves or communal reserves. This has been the case since independence and is still continuing. In contrast, other ethnic groups, such as the Maasai, have been recognized as tribes and consequently been able to enjoy and relate rights derived from such recognition, thus providing different treatment. The court accordingly finds that if other groups which are in the same category of communities which lead a traditional way of life and with cultural distinctiveness, highly dependent on the natural environment as the Ogieks, were granted recognition of their status and the resultant rights, the refusal of the respondent to recognize and grant the same rights to the Ogieks due to their way of life as hunter-gatherer community amounts to distinction based on ethnicity and or other status in terms of Article 2 of the Charter. With regard to the respondent's submission that following the adoption of the new Constitution in 2010, all Kenyans enjoy equal opportunities in terms of education, health, employment, and access to justice, and there is no discrimination among different tribes in Kenya, including the Ogieks. The court notes that indeed, the 2010 Constitution of Kenya recognizes and accords special protection to indigenous populations as part of marginalized community. And the Ogieks could theoretically fit into that category and benefit from the protection of such constitutional safeguards. All the same, this does not diminish the responsibility of the respondent with respect to the violation of the rights of the Ogieks not to be discriminated against between the time the respondent became a party to the Charter and when the respondent's new constitution was enacted. In addition, as stated above, the prohibition of discrimination may not be fully guaranteed with the enactment of laws which condemn discrimination. The right can be effective only when it is actually respected and in this vein, the persisting eviction of the Ogieks, the failure of the authorities of the respondent to stop such evictions and to comply with the decisions of the national courts demonstrate that the new constitution and the institutions which the respondents has set up to remedy past or ongoing injustices are not fully effective. On the respondents' purported justification that the evictions for the lack of recognition of the Ogieks' indigenous or tribal status and denying them the associated rights derived from such status. Moreover, the court recalls its earlier finding that, contrary to what the respondents is asserting, the Mau forest has been allocated to other people in a manner which cannot be considered as compatible with the preservation of the natural environment, and that the respondent itself concede that the depletion of the natural ecosystem cannot be entirely imputed on the Ogieks. In the light of the foregoing, the court finds that the respondent, by failing to recognize the Ogieks' status as a distinct tribe like other similar groups, and thereby denying them the right available to other tribes, violated Article 2 of the Charter. Alleged violation of Article 4 of the Charter. Article 4 of the Charter stipulates that, quote, human beings are inviolable. Every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of this right. End of quotation. The right to life is the cornerstone on which the realization of all other rights and freedoms depend. The deprivation of someone's life amounts to the eliminating the very holder of these rights and freedoms. Article 4 of the Charter strictly prohibits the arbitrary privation of life. Contrary to other human rights instruments, the Charter establishes the link between the right to life and the inviolable nature and integrity of a human being. The court finds that this formulation reflects the indispensable correlation between these two rights. The court notes that the right to life under Article 4 of the Charter is a right to be enjoyed by an individual irrespective of the group to which he or she belongs. The court also understands that the violation of economic, social, and cultural rights, including through forced eviction, may generally endanger conditions unfavorable to life. However, the court is of the view that the sole fact of eviction and deprivation of economic, social, and cultural rights may not necessarily result in the violation of the right to the life under Article 4 of the Charter. The court considers that it is necessary to make a distinction between the classical meaning of the right to life and the right to decent existence of a group. According to Article 4 of the Charter, relates to the physical rather than the existential understanding of the right to life. In the instant case, it is not in dispute between the parties that the Mau forest has for generations been the environment in which the Ogiek population has always lived, and that their livelihood depends on it. As a hunter-gatherer population, the Ogieks have established their homes, collected and produced food, medicine, and ensured other means of survival in the Mau forest. There is no doubt that their eviction has adversely affected their decent existence in the forest. According to the applicant, some members of the Ogiek population died at different times due to lack of basic necessities such as food, water, shelter, medicine, exposure to the elements, and diseases subsequent to their forced eviction. The court notes, however, that the applicant has not established the causal connection between the evictions of the objects by the respondent and the deaths alleged to have occurred as a result. The applicant has not adduced evidence to this effect. In view of the above, the court finds that there is no violation of Article 4 of the Charter. Alleged violation of Article 8 of the Charter. Article 8 of the Charter provides, we quote, freedom of conscience, the profession and free practice of religion shall be guaranteed. No one may, subject to law and order, be submitted to measures restricting the exercise of these freedoms. End of quotation. The above provision requires state parties to fully guarantee freedoms of conscience, the profession and free practice of religion. The right to freedom of worship offers protection to all forms of belief regardless of denominations, theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief. The right to manifest and practice religion includes the right to worship, engage in rituals, observe days of rest, and wear religious garb, allow individuals or groups to worship or assemble in connection with religion or belief, and to establish and maintain places for these purposes, as well as to celebrate ceremonies in accordance with the precepts of other religion or beliefs. The court notes that in the context of traditional societies where formal religious institutions often do not exist, the practice and profession of religion are usually inextricably linked with land and the environment. In indigenous societies in particular, that freedom to worship and to engage in religious ceremonies depend on access to land and the natural environment. Any impediment to or interference with accessing the natural environment, including land, severely constrains their ability to conduct or engage in religious rituals with considerable repercussions on the enjoyment of their freedom of worship. In the instant case, the court notes that the record before it that the Ogek's religious sites are in the Mau Forest, and they perform their religious practices there. The Mau Forest constitutes their spiritual home and is central to the practice of their religion. It is where they bury the dead according to their traditional rituals, where certain types of trees are found for use of worship, and it is where they have kept their sacred sites for generations. The records also show that the Ogek's population can no longer undertake their religious practices due to their eviction from the Mau Forest. In addition, they must annually apply and pay for a license to them to have access to the forest. In the opinion of the court, the eviction measures and these regulatory requirements interfere with the freedom of worship of the Ogek population. Article 8 of the Charter, however, allows restrictions on the exercise of freedom of religion in the interest of maintaining law and order. Though the respondent can interfere with the religious practices of the OGICs to protect public health and maintain law and order, these restrictions must be examined with regard to their necessity and reasonableness. The court is of the view that rather than evicting the OGICs from the Mau Forest, thereby restricting their rights to practice their religion, there were other less onerous measures that the respondent could have put in place that could have ensured their continued enjoyment of the rights while ensuring maintenance of law and order and public health. These measures include undertaking sensitization campaigns or to the OGIC, or on the requirements to bury their dead in accordance with the requirements of the Public Health Act, and in collaborating towards maintaining the religious sites and waiving the fees to be paid by the OGICs to access their religious sites. On the contention that the OGICs have abandoned their religion and converted to Christianity, the court notes from the record before it, specifically from the testimony of the applicant's witnesses, that not all the OGICs have converted to Christianity. Indeed, the respondent has not submitted any evidence to support its position that the adoption of Christianity means a total abandonment of the OGIC traditional religious practices. Even though some members of the OGICs might have been converted to Christianity, the evidence before this court shows that they still practice their traditional religious rites. Accordingly, the alleged transformation in the way of life of the OGICs and their manner of worship cannot be said to have entirely eliminated their traditional spiritual values and rituals. From the foregoing, the court is of the view that given the link between indigenous population and their land for purposes of practicing their religion, the evictions of the OGIC from the Mau Forest rendered it impossible for the community to continue its religious practice and is an unjustifiable interference with the freedom of religion of the OGICs. The court therefore finds that the respondent is in violation of Article 8 of the Charter. Alleged violation of Article 17, Sub-Article 2 and Sub-Article 3 of the Charter. Article 17 of the Charter provides, we quote, 1. Every individual shall have the right to education. 2. Every individual may freely take part in the cultural life of his community. 3. The promotion and protection of morals and traditional values recognized by the community shall be the duty of the state. End of quotation. The right to culture as enshrined in Article 17, Sub-Article 2 and Sub-Article 3 of the Charter is to be considered in a dual dimension in both its individual and collective nature. It ensures protection on the one hand of individuals' participation in the cultural life of their community, and on the other oblige the state to promote and protect traditional value of the community. Article 17 of the Charter protects all forms of culture and places strict obligations on the state parties to protect and promote traditional values. In a similar fashion, the Cultural Charter for Africa obliges states to adopt a national policy which creates conditions conducive for the promotion and development of culture. The Cultural Charter specifically stresses, quote, the need to take account of national identities, cultural diversity being a factor making for balance within the nation and a source of mutual enrichment for the various communities, end of quotation. The protection of the right to culture goes beyond the duty not to destroy or deliberately weaken minority groups, but requires respect for and protection of their cultural heritage, essential to the group's identity. In this respect, culture should be construed in its widest sense, encompassing the total way of life of a particular group, including the group's language, symbols, such as dressing codes, and the manner the group constructs shelter, engages in certain economic activities, produces items for survival, rituals such as the group's particular way of dealing with problems and practicing spiritual ceremonies, identification and veneration of its own heroes or models, and shared values of its members, which reflects its distinctive character and personality. The court notes that in the context of indigenous population, the preservation of their culture is not particularly important. The court notes that in the context of indigenous population, the preservation of their culture is of particular importance. Indigenous populations have often been affected by economic activities of other dominant groups and large-scale developmental programs due to their obvious vulnerability, often stemming from their number of or traditional ways of life. Indigenous populations even have at times been the subject and easy targets of deliberate policies of exclusion, exploitation, forced assimilation, discrimination, and other forms of persecution, whereas some have encountered extinction of their cultural distinctiveness and continuity as a distinct group. The United Nations Declaration on Indigenous People states that, we quote, indigenous people and individuals have the right not to be subjected to forced assimilation or destruction of their culture, end of quotation. And states shall provide effective mechanism to prevent any action that deprives them of, quote, their integrity and distinct people as distinct people, or of their cultural values or ethnic identities, end of quotation. The United Nations Committee on Economic, Social, and Cultural Rights, in its general comments on paragraph A, sub Article 1 of Article 15, also observed that, quote, the strong communal dimension of indigenous peoples' cultural life is indispensable to their existence, well-being, and full development, and includes the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired, end of quotation. In the instant case, the court notes from the records available before it that the Ogiek population has a distinct way of life, centered and dependent on the Mau Forest complex. As a hunter-gatherer community, they get their means of survival through hunting animals and gathering honey and fruits. They have their own traditional clothes, their own language, distinct way of entombing the dead, practicing rituals and traditional medicine. and their own spiritual and traditional values, which distinguish them from other communities living around and outside the Mau Forest Complex, thereby demonstrating that Ogieks have their own distinct culture. The court notes, based on the evidence available before it, and which has not been contested by the respondent, that the Ogieks have been peacefully carrying out their cultural practices until their territory was encroached upon by outsiders and they were evicted from the Mau Forest. Even in the face of this, the Ogieks still undertake their traditional activities, traditional wedding ceremonies, oral traditions, folklores, and songs. They still maintain their clan boundaries in the Mau Forest, and each clan ensures the maintenance of the environment within the boundary it is allocated. However, in the course of time, the restrictions on access to and evictions from the Mau Forest have greatly affected their ability to preserve their tradition. In view of this, the court holds that the respondent interfered with the enjoyment of the right to culture of the Ogiek population. Having found that there has been interference in the by the respondent with the cultural right of the Ogiek, the next issue for the court to determine is whether or not such interference could be justified by the needs to attain a legitimate aim under the Charter. In this regard, the court notes the respondent's contention that the Ogiek population has evolved on their own by adopting a different culture and identity, and that in any event the eviction measures the respondent effected against them were aimed to prevent adverse impact on the Mau Forest, which was caused by the Ogiek lifestyle and culture. With regard to the first contention, that the Ogieks have evolved and their way of life has changed through time to the extent that they have lost their distinctive cultural identity, the court reiterates that the respondent has not sufficiently demonstrated that this alleged shift and transformation in the lifestyle of the Ogieks has entirely eliminated their cultural distinctiveness. In this vein, the court stresses that stagnation of the existence of a static way of life is not a defining element of culture. Culture or cultural distinctiveness. It is natural that some aspects of indigenous populations, culture such as certain way of dressing or group symbols, could change over time. Yet the values, mostly the invisible traditional values embedded in their self-identification and shared mentally, often remain unchanged. Insofar as the Ogiek population is concerned, the testimony tendered by Mrs. Mary Japkemei, a member of the Ogiek community, attests that the Ogieks still have their traditional values and cultural ceremonies which make them distinct from other similar groups. In addition, the court notes that, to some extent, some of the alleged changes in the way the Ogieks used to live in the past are caused by the restrictions put in place by the respondent itself on their right to access their land and natural environment. With respect to the second contention, that the eviction measures were in the public interest of preserving the natural environment of the Mau Forest Complex, the court first notes that Article 17 of the Charter does not provide exceptions to the right to culture. Any restrictions to the right to culture shall accordingly be dealt with in accordance with Article 27 of the Charter, which stipulates that, we quote, "Every individual shall have duties towards his family and society, the state and other legally recognized communities, and their international community. 2. The right and freedom of each individual shall be exercised with due regard to the right of others, collective security, morality, and common interest." End of quotation. In the instant case, the restrictions of cultural rights of the Ogiek population to preserve the natural environment of the Mau Forest Complex may in principle be justified to safeguard the common interest in terms of sub-Article 2 of Article 27 of the Charter. However, the mere assertion by a state party of the existence of a common interest warranting interference with the right to culture is not sufficient to allow the restriction of the right or sweep away the essence of the right in its entirety. Instead, in the circumstances of each case, the state party should substantiate that its interference was indeed genuinely prompted by the need to protect such common interest. In addition, the court has held that any interference with the rights and freedoms guaranteed in the Charter shall be necessary and proportional to the legitimate interest sought to be attained by such interference. In the instant case, the court has already found that respondent has not adequately substantiated its claims that the eviction of the Ogiek population was to the preservation of the natural ecosystem of the Mau forest. Considering that the respondent has interfered with the cultural rights of the Ogieks through the evictions, and given that the respondents invoked the same justification of preserving the natural ecosystem for its interference, the court reiterates its position that the interference cannot be said to have been warranted by an objective and reasonable justification. Although the respondent alleges generally that certain cultural activities of the Ogieks are inimical to the environment, it has not specified which particular activities and how these activities have degraded the Mau forest. In view of this, the purported reason of preserving the natural environment cannot constitute a legitimate justification for the respondents' interference with the Ogieks' exercise of their cultural right. Consequently, the court deems it unnecessary to examine further whether the interference was necessary and proportional to the legitimate aim invoked by the respondent. The court therefore finds that the respondent has violated the right to culture of the Ogiek population contrary to Article 17, Sub-Article 2 and Sub-Article 3 of the Charter by evicting them from the Mau forest area, thereby restricting them from exercising their cultural activities and practices. Alleged violation of Article 21 of the Charter. Article 21 of the Charter states, and we quote, "All peoples shall freely dispose of their wealth and natural resources. The right shall be exercised in the exclusive interest of the people. In no case shall a people be deprived of it." 2. In case of spoliation, and dispossessed people shall have the right to the lawful recovery of its property, as well as to an adequate compensation. The right to the free disposal of wealth and natural resources shall be exercised without prejudice to the obligation of promoting international economic cooperation based on mutual respect, equitable exchange, and the principle of international law. 4. States parties to the present Charter shall individually and collectively exercise the right to freely disposal of their wealth and natural resources with a view of strengthening African unity. Fifth, state parties to the present charter shall undertake to eliminate all forms of foreign exploitation, particularly that practiced by international monopolies, so as to enable their peoples to fully benefit from the advantages derived from their national resources. End of quotation. The court notes in general terms that the Charter does not define the notion people. In this regard, the point has been made that the drafters of the Charter deliberately omitted to define the notion in order to permit a certain flexibility in the application and subsequent interpretation by future users of the legal instrument, the task of fleshing out the Charter being left to the human rights protecting bodies. It is generally accepted that in the context of the struggle against foreign domination in all its forms, the Charter primarily targets the people comprising the population of the countries struggling to attain independence and national sovereignty. In the circumstances, the question is whether the notion people used by the Charter covers not only the population as the constituent element of the state, but also the ethnic groups or communities identified as forming part of the said population within a constituted state. In other words, the question that arises is whether the enjoyment of the rights unquestionably recognized for the constituent peoples of the population of a given state can be extended to include sub-state ethnic groups and communities that are not of that population. In the view of the court, the answer to the question is in the affirmative, provided such groups or communities do not call into question the sovereignty and territorial integrity of the state without the latter's consent. It would, in fact, be difficult to understand that the state, which are the authors of the Charter, intended, for example, to automatically recognize for the ethnic groups and communities that constitute their population the right to self-determination and independence guaranteed under Article 20, Subarticle 1 of the Charter, which in this case would amount to a veritable right to secession. On the other hand, nothing prevents other people's rights, such as the right to development under Article 22, the right to peace and security, Article 23, or right to healthy environment, Article 24, from being recognized where necessary, specifically for the ethnic groups and communities that constitute the population of a state. In the instant case, one of the rights at issue is the right of peoples to freely dispose of their wealth and natural resources guaranteed under Article 21 of the Charter. In essence, as indicated above, the applicant alleges that the respondent violated the aforesaid right insofar as, following the expulsion of the Ogieks from the Mau forest, they were deprived of their traditional food resources. The court recalls in this regard that it has already recognized for the Ogieks a number of rights to their ancestral land, namely the right to use usus and the right to enjoy the produce of the land, fructus, which presupposes the right of access to and occupation of the land. Insofar as those rights have been violated by the respondent, the court holds that the latter has also violated Article 21 of the Charter, since the OGICs have been deprived of their right to enjoy and freely dispose of the abundance of food and produce by their ancestral lands. Alleged violation of Article 22 of the Charter. Article 22 of the Charter provides that, 1, we quote, all peoples shall have the right to their economic, social, and cultural development with due regards to their freedom and identity and in the equal enjoyment of their common heritage of mankind. 2, states shall have the duty, individually or collectively, to ensure the exercise of the right to development. End of quotation. The court reiterates its view above with respect to Article 21 of the Charter, that the term peoples in the Charter comprises all populations and constitutes and constitutive element of a state. These populations are entitled to social, economic, and cultural development, being part of the peoples of the state, of a state. Accordingly, the OGIC population has the right under Article 22 of the Charter to enjoy their right to development. The court considers that Article 22 of the Charter should be read in light of Article 23 of the United Nations Development Program, which provides as follows. Indigenous people have the right to determine and develop priorities and strategies for exercising their right to development. In particular, indigenous people have the right to be actively involved in developing and determining health, housing, and other economic and social programs affecting them, and as far as possible to administer such programs through their own institutions. End of quotation. In the instant case, the court recalls that the OGICs have been continuously evicted from the Mau forest by the respondent without being effectively consulted. The eviction have adversely impacted on the economic, social, and cultural development. They have also not been actively involved in developing and determining health, house, and other economic and social programs affecting them. The court therefore holds that the respondent violated Article 22 of the Charter. Alleged violation of Article 1 of the Charter. Article 1 of the Charter declares, we quote, the member states of the Organization of African Unity, now Africa, Organization of now African Union, parties to the present Charter shall recognize the rights, duties, and freedoms enshrined in this Charter, and shall undertake to adopt legislative or other measures to give effect to them. End of quotation. The court observes that Article 1 of the Charter imposes on state parties the duty to take all legislative and other measures necessary to give effect to the rights and freedoms guaranteed in the Charter. In the instant case, the court observes that by enacting its constitution in 2010, the Forest Conservation and Management Act number 34 of 2016 and the Community Land Act, Act number 27 of 2016, the respondent has taken some legislative measures to ensure the enjoyment of rights and freedoms protected under the Charter. However, these laws were enacted relatively recently. This court has also found that the respondent failed to recognize the Ogeeks, like other similar groups, as a distinct tribe, leading to a denial of access to their land in the Mao Forest and the consequential violation of their rights under Article 2, Article 8, Article 14, Article 17, 2 and 17 sub Article 3, Article 21, and Article 22. In addition to these legislative lacunae, the respondent has not demonstrated that it has taken other measures to give effect to these rights. In view of the above, the respondent has violated Article 1 of the Charter by not taking adequate legislative and other measures to give effect to the rights enshrined under Article 2, 8, 14, 17, Sub-Article 2 and Sub-Article 3, 21 and 22 of the Charter. Remedies and reparation. The court's power of reparations is set out in Article 27, Sub-Article 1 of the Protocol, which states that, we quote, if the court finds that there has been a violation of a human and people's rights, it shall make appropriate orders to remedy the violation, including the payment of fair compensation and reparation. End of quotation. Further, pursuant to Rule 63 of the rules, quote, the court shall rule on the request for reparation submitted in accordance with sub-rule 5 of Rule 34 of these rules by the same decision establishing the violation of a human and people's right, or if the circumstances so require, by a separate decision. End of quotation. The court decides that it shall rule on any other form of reparations in a separate decision, taking into consideration the additional submissions from the parties. Costs. Neither the applicant nor the respondent made claims as to cost. The court notes that Rule 30 of its rules states that, quote, unless otherwise decided by the court, each party shall bear its own cost. End of quotation. The court shall rule on the cost when making its ruling on other forms of reparation. For these reasons, the court unanimously on jurisdiction dismisses the objection to the court's material jurisdiction to hear the application. 2. Dismisses the objection to the court's personal jurisdiction to hear the application. 3. Dismisses the objection to the court's temporal jurisdiction to hear the application. And 4. Declares that it has jurisdiction to hear the application. On admissibility, 1. The court dismisses the objection to the admissibility of the application on the ground that the matter is pending before the African Commission on Human and People's Rights. 2. Dismisses the objection to the admissibility of the application on the grounds that the court did not conduct a preliminary examination of the admissibility of the application. 3. Dismisses the objection to the admissibility of the application on the grounds that the author of the application is not the aggrieved party in the complaint. 4. Dismisses the objection to the admissibility of the application on the grounds of failure to exhaust local remedies. And 5. Declares the application admissible. On the merits, 1. The court declares that the respondent has violated Articles 1, 2, 8, 14, 17, Subarticle 2 and Subarticle 3, Article 21 and Article 22 of the Charter. 2, declares that the respondent has not violated Article 4 of the Charter. 3, orders the respondent to take all appropriate measures within a reasonable time frame to remedy all the violations established and to inform the court of the measures taken within 6 months from the date of this judgment. 4, reserves its ruling on reparations. 5, requests the applicant to file submissions on reparations within 60 days from the date of this judgment, and thereafter the respondent shall file its response thereto within 60 days of receipt of the applicant's submission on reparation and cost. Done at Arusha, this 26th day of May 2017, in English and French, the English text being authoritative. Signed by Sylvain Ore, the President, Gerard Nyungeko, Judge, Agostino Ramadhani, Judge, Duncan Tambala, Judge, Elsie Thompson, Judge, El Haji Gise, Judge, Rafa Benasho, Judge, Solomi B. Bosa, Judge, Angelo V. Matuse, Judge, and Robert Eno, the Registrar.
Thank you, Honorable Justice Agostino Ramadhani. So this is the end of the hearing on the matter related to African Commission on Peoples and Human Rights versus Kenya, Republic of Kenya. So the judgment was read by Agostino Ramadhani, former president of the court. Yes, Counsel? Yes, go ahead.
Thank you very much, my Lord. I'm under instructions by the applicant, the African Commission on Human and People's Rights, to make a small application under Rules 34 sub Rule 5 and Rule 63 of the Honorable Court, which my Lord Justice Ramadhani has just cited with regard to reparations. And my Lord, the applicant and its counsel start by thanking this Honorable Court for delivering a comprehensive judgment on the issues that were before the court. The applicant acknowledges that the court has ruled in favor of the application and directed the applicant to file its submissions on reparations within a period of 60 days, as is provided for by Rule 34 sub Rule 5 as read with Rule 63. The applicant is constrained to bring to this Honorable Court's attention that it fears it may not be able to meet the period of 60 days for the reason that the case is complex. The people at issue, which are the Oge community of the Mau Forest of Kenya, are many, and the Mau Forest itself is very far away from Nairobi and of course from the seat of the applicant in Banjul in the Republic of the Gambia. The applicant will have to organize a couple of sittings with the Oge community, and therefore the applicant respectfully requests this Honorable Court to extend the timeline for it to file its submissions to 90 days rather than the 60, and the applicant endeavors that they will try their best to finish the task within the shortest time possible and attain it within the 90 days. And finally, my lords, we recognize that the court may choose to give a decision on this application now or may choose to deliberate on the application and render a ruling later, including by correspondence from the court, and we are comfortable with that. And this small and brief application is the application of the applicant. I'm much obliged, my lords.
Thank you, Counsel.
No, but we could do it now. We're ready to reply to that.
Okay, Counsel, you know that it's a contradictory procedure. So we will give the floor to the respondent if they have something to say about it. And we will render our decision.
Thank you, Your Lordships. We would not be opposing the application made by counsel for the applicant, but we would like an equal number of time to respond to the issues that they will have raised in their submissions. That is all, Your Lordships.
What you see, it's just 17.
She said that she includes provided that we give the same time. She they agree. I mean, do we need to wait that we put it in writing? No,
Can you make that decision?
Okay, since the respondent agreed with your request, I think that we can grant you the time you are requesting for. But what time do you request for?
2 days.
My lord, I requested for 90 days, and my learned colleague requested for a similar period of time.
Yes, similar period, no problem. Okay, so 90 days are granted both parties, but of course the other parties, they will benefit for this period when you submit, after you have submitted. Okay? Thank you.